Good afternoon to everyone, and good evening for those who are in the very night hours of the day already. Thank you very much for joining us in this conversation, which is held for the purpose of presenting the book Latin America, International Law in the 21st Century, edited by Oxford University Press. Before introducing the topic of the panel and our distinguished speakers, a few important clarifications. The panel will run for about an hour and 15 minutes. In terms of structure, the three co-editors of the book will present us their volume, followed by the comments of our discussant. In turn, the co-editors will have some minutes for reactions or further remarks. And at the very end, there will be time for Q&A. You can start posting your questions from the very beginning. As you can see below, there is a specific window for Q&A. And I will make sure to transmit to the panelists your questions for consideration. Moving on with the presentations, the panel is organized by the EULAS Network. EULAS is the acronym for the EU Latin America Academic Synergies, which is a Jean Monnet network focused on research, innovation, and collaboration between Europe, Latin America, and the Caribbean. The network, which is coordinated by the Institut de Barcelona d'Estudis Internacionals, IBEI, is composed of 24 higher education institutions across both continents. A special thanks to Emily Jones, a member of the EULAS team who was in charge of putting this panel together and making this possible. She's now in the background making sure everything runs properly during our conversation. Moving forward, with regards to the moderation of the panel, my name is Joaquin Caprarulo, and I am a doctoral fellow at the LAC-EU Network, a partner project to EULAS, supporting 12 doctoral researchers conducting research on the relationship between both regions. I invite you all to follow both projects on social media for similar activities and the EULAS blog for very interesting analysis on similar topics. Before introducing our panelists, I would like to allow myself a brief introduction to the topic of the panel and the content of the conversation we're about to have. Personally, I had the possibility of engaging with the book, and I believe it's a book that represents a significant contribution to the discussion about the role of Latin America and the Caribbean in the overall project of international law. I think that among its multiple accomplishments, the book brings not only a critical view on the past, but also sheds light on the present and future of international law as a discipline, practice, and discourse within the region, making it from a very comprehensive analysis. In addition, different to other similar projects in the field, the book tries to take stock of different approaches to the region as a unity, rather than the sum of different national realities. And most importantly, I think the book foregrounds the claim that Latin America and the Caribbean have been reshaping its international law canon during the first quarter of the ongoing century, a canon that is very distinct to the ones that have dominated the discipline in the 20th century. Nevertheless, it's also possible that many participants have felt attracted to this panel due to recent events in the region, which have drastically affected the terms of the conversation about international law in Latin America. As such, it's impossible to go blind about the shift in the US strategy towards the region, which will also, of course, invite us to discuss more broadly how the book can help us understand what is going on in Latin America and the Caribbean. For sure, this scenario has opened numerous questions for the years to come that the book can definitely help us think about. But the great news is that we couldn't have a more suitable set of speakers than these ones for such a complex challenge. So to begin with, we will listen to the three co-editors of the book, starting by Professor Alejandro Chehtman. He's professor of law and dean at the Law School of the University Torcuato de Tella, and a fellow at the Argentine National Research Council, CONICET. His main research interests are public international law, international criminal law, international humanitarian law, and constitutional law, with a special interest in philosophical and empirical issues. Second, we will listen to Professor Sergio Puig de la Parra. He holds the joint chair in international economic law at the European University Institute, where he is affiliated with both the Law Department and the Robert Schuman Center for Advanced Studies. Since March 2025, he has also served as the director of the Max Weber program at EUI He specializes in international economic law with focus on investment and trade law, business and human rights, and empirical legal methods. Third, Professor Alexandra Huneeus will close the first part of the panel. She's a FSU Basecomb Professor of Law and Director of the Center of Law, Society and Justice at the University of Wisconsin-Madison. She currently serves as Director of the Center for Law, Society and Justice, and she's co-chair of the University of Wisconsin Human Rights Program, which she co-founded, and the Director of the Global Legal Studies Program. And subsequently, this presentation will receive the reactions of Professor Cecilia Baillet, who is Professor of International Law at the University of Oslo, the UN Independent Expert on Human Rights and International Solidarity, and the co-chair of the Latin American Interest Group at the American Society of International Law. She has published The Construction of the Customary Law of Peace, Latin America and the Inter-Caribbean Court of Human Rights by Edward Elgar in 2021. So, with further ado, I will give the floor to Alexandra.
Maybe I will start first. Yeah, there we are. Excellent. So thank you so much, Joaquin, for your kind words about the book. And thank you very much, EULAS, and also Emily for organizing this webinar. It's really a treat to be discussing the book and to listen or to hear from Cecilia's comments, to which I very much look forward. As Joaquin mentioned, it is a very difficult time to be discussing the issue of Latin American international law, current events, which I do not need to go into in depth at this moment, are worrying, and I'm sure we're thinking in some detail about or where is Latin American international law or international law more broadly going. But I'll probably leave that to the Q&A session or to the answer to Cecilia's comments. We were kindly asked to present the main ideas and what is new about the book. And so I'll concentrate on how we came about to discuss and think and ultimately develop the idea of the book. So in 1909, as many of you will know, Chilean jurist Alejandro Alvarez made this claim for the existence of a regional law of the Americas, and he published a very an extraordinary paper in the American Journal of International Law, which he later developed into a book. And his objective, as we say in the introduction to the book, was to carve out a more prominent place for Latin America in the then emerging United States-led geopolitical order. So his project was a project of what we call in the book a Pan-American approach to Latin American international law, with the United States at its apex, and he defended a very close alliance, or at least political and intellectual proximity between Latin America and the US, making very strong claims in favor, for instance, of the Monroe Doctrine, something which now would seem quite unusual. But he, I think, or we think, captured very well a sensibility of what people like Liliana Obregón have called the criollo international law, or the criollo sensibility towards international law, or at least Latin American approaches to international law. Now, this book, as I said, started from conversations with Alex and Sergio about the feeling we had of Latin American ideas, voices, and ultimately sensibilities not being adequately represented, discussed, taken into consideration, influential in contemporary debates on international law. And so we started with the idea of producing a volume that will capture much of what was being discussed and developed in the region. Now, with the conversations, of course, projects mutate, and eventually when we got to read the whole volume, the chapters, we realized that there was something bigger. and I think more interesting. And the idea, if we compare it to what Alejandro Alvarez was doing at the turn of the 19th to the 20th century, the critical difference was that the geopolitical context was entirely different, and that resulted in many difference in terms of sensibilities, approaches, ideas about Latin American international law. So, for instance, the dynamics of regionalism when we started the book, and this is an important aspect to which I'm sure Alexandra and or Sergio will further develop. The dynamics in the region had mutated from a political order dominated by the US to a political order or a political economic order where China was beginning or had consolidated in a very powerful economic actor. And the US had retreated from the region, paying attention to other regions in the world. And as we have seen from Joaquin's starting comments, that may have changed very, very dramatically with the new Trump administration. Secondly, there was a growing mismatch between the expectations of the peoples in Latin America and the performance of the government, which led to democratic stagnation and backsliding, a crisis of the democratic rule, the rise of populism, creating tensions in the region, which was entirely different from the situation in the early 20th century. There's the environmental degradation and the place that Latin America, in particular the Amazon, occupies in any relevant discussion on environmental regulation, environmental international law. And so that also created pressures on scholarship and on countries in the region to develop an agenda with regards to the regulation of this environmental degradation and the ways in which it could be addressed. And of course, technological capacities have changed, and Latin America was or has been or is struggling to get investment to produce the technological leap that can make it still or crucially still relevant for economic development in the world. And of course, there's the connection between technological capacities and the rapid development of technology with the key importance of certain commodities, including energy, but also rare earth deposits and other goods that are produced or are kept in the region. So in a sense, the general context was very different from the one that Alejandro Alvarez envisaged. And finally, not less importantly, there had been critical changes in terms of the sensibilities and approaches in terms of scholarship to international law in the region, with a much more professionalized academia versus a world where international law was essentially developed by diplomats and academia, which is much more globalized, intellectually ambitious, and which is also mostly or generally educated in the global north. So in order to start, we found that these changes forced the works in the book in a different direction to the one that Alejandro Alvarez had chosen, and that it was interesting to explore what these ideas, developments, interventions, contributions were. Now, before I pass the floor to my colleague Sergio Puig, let me say a few words about the cover, which is, I think we can go to the next slide. Alex, if you can help me with this. So the cover is an installation by Colombian artist Doris Salcedo called Shibboleth. It was an installation at the Tate Modern Gallery in London in 2007, in a huge place called the Turbine Hall. It's a 167 meters long crack that divided the floor of this Turbine Hall in Tate Modern. A first obvious parallel with the book is that just as the installation, the book is published for a global audience with Oxford University Press, a leading publisher in English, although the Spanish translation is forthcoming in the next few months, and seeks to advance a global conversation rather than a more parochial exercise of self-reflection in the region. But I think there are deeper and perhaps more important reasons for our shared election of this cover. First, the title Shibboleth alludes to a biblical passage in which members of a group recognized those who belonged to the group from those who did not by the way in which they pronounce this particular word. So it is, as commentators of Salcedo's work say, it's an invitation to reflect on borders, separation, exclusion, displacement, immigration, and racism, all issues that are and have been at the core of debates on Latin American international law in the last few decades, and particularly of the brand of Latin American international law that we are interested in the book. But the shibboleth is also a metaphor of a deep wound that conveys the pain that these divisions and tragedies of our region have created and still generate. And although the crack in the Turing Hall has been filled since 2007, it is claimed that it is still there and that it can still be perceived just like a scar. The crack is thereby also a call for memory, which is, again, something Latin American international law care deeply about. Now I will give the floor to Sergio. Thank you very much.
Thank you so much, Alejandro, and thank you so much to Joaquin and Cecilia, and as well as Alejandra for being here. So what I would do in now the next 5 to 10 minutes, I will introduce the chapters and also explain a little bit of the motivations of the book. So the elements of the book include 30 chapters, plus an introduction and an epilogue. And the introduction and the epilogue are written by us, the co-editors of the book, whom also each of us have a chapter in the different sections, or one chapter in a different section. The volume is divided in 5 parts, starting with a historical background, where we try to analyze, the different ways in which Latin American international law has evolved in the last 200 years. Then we have a theory and methods section, and here we have different contributions that focus on the methodological and theoretical contributions of the Latin American international law canon, and Alexandra will explain a little bit more of what we refer as the canon. One of the things that I can zoom in is perhaps my chapter, which is on methods, and basically uses international economic law to discuss the ways in which Latin America has been a pioneer or has been in some way a fertile ground of socio-legal studies that, at least in the field of international economic law, that probably challenged also the conventional view of how international economic law was this very fair, very nice international law where compliance was the norm, to focus more on the distributional impacts and how it affects different aspects of our daily life. So I think that section, at least for me, is one of my favorites, I would say, and maybe because of my scholarship as well has focused more on methods. Then we have the section of institutions and practice. And I think, if I'm not incorrect, there is a wonderful, beautiful article by Alexandra here on the international or the American human rights system, which is also quite powerful. But I let her speak of different of her chapter, or Alejandro, if he wants to talk about his wonderful chapter as well, which I believe is in the next section, which is the new doctrines as well. And we finished with one more forward-looking section on contemporary challenges and what we see as the region's main problems. So we had also tried to do in this process of bringing together different authors is to try to have people from the region, but also outside, and people from different generations that could come with different traditions and talents. Of course, we could only get 30 people, but I think we missed many amazing people, and I think in that sense we couldn't make justice to the wonderful contributions of people who are from Latin America or who have written on Latin America. I think a particular issue for us that we live a little bit, saddened perhaps. No, saddened, no, it's not the word, but I think it's a depth that we have is perhaps not having enough people from Central America and perhaps the Caribbean and look at this more intensely, in part because our networks were more limited to other parts of Latin America, or perhaps because of as well, the language, for example, maybe thinking of Francophone contributions and perhaps, were not as prevalent. But I think we did a good job in general to try to get people from different disciplines and different backgrounds and traditions. Now, in general, and I think, I would let Alexandra explain a little bit more the specifics of the contributions, but we in these 5 sections we try to come with an analysis and revisitation of the doctrines and arguments of the past and how Latin American international law continues to do that through its scholarship. We also try to highlight how the new Latin American international law has not been constructed only by diplomats or foreign ministers, but also by judges, civil society, and notably indigenous peoples and other voices that have been previously marginalized or that do not feature so prominently in other regions, like, for example, in Europe. And again, right, I think notably is the contribution of the Inter-American system in the dialogue with domestic courts and how that has created this back and forth and dialectic between domestic and international legal systems in contemporary practice of Latin American law. And I think, one key reflection I think I get from the book is how the United States and Europe, in a way, or in different ways, have been displaced perhaps in some parts of Latin America, and perhaps that's why we see such a violent response right now of the US, that they were displaced as one of the main interlocutors in key parts of Latin America. China is now a key player, and this is not unlike past in the big past, right? I mean, if we look at the last 200 years, perhaps, or the last 100 years, perhaps there was a much more American-dominated world, but also American-dominated Latin America. But if we look more to the times where Europe dominated Latin America, the presence of China, or the relation with China, was much more intense than what had been in the last 2 years. So it shouldn't be completely a surprise. But what is really relevant, at least for us, is how that has permeated into international law, and we offer some reflections, if you may, in the epilogue. Maybe with that, I pass the microphone to Alexandra to continue our exposition. Thank you so much.
For the last part of our exposition, I am going to talk a little bit about the epilogue that we wrote. We did not set out to write an epilogue or to make any claims about, in broad strokes, about a Latin American international law in the way that Alejandro Alvarez had argued for the existence of a distinct practice in the region. That was not our goal. We simply wanted to take stock of and look at, explore, and expose the study and practice of Latin American international law in our time, given all of the differences that Alejandro Chehtman started with. Now, as we were closing the volume and began to read and reread these chapters taken together, we realized that there were certain strands of commonality between them that we wanted to highlight because we thought they were important and did point to a new era in the practice and study of Latin American international law. So we begin the epilogue, going back over the Pan-Americanism, as Alejandro Chehtman described it earlier, which is, very much embodied by the Monroe Doctrine and the Latin American Criollo support of that doctrine. And then the reviewing again, looking again at the Pan-Hispanic counter-canon, the pushback against Pan-Americanism, a more nationalist understanding or regionalist understanding, without giving or ceding such power to the United States. And we look at how that dialectic between Pan-Americanism and Pan-Hispanicism had characterized the debates around Latin American international law through to our time. But without denying that they still exist and have come back with force since January 3rd, we also noted that there was so much more going on that seemed to be neglected in past accounts of Latin American international law. And what was going on are these strands of shared practice and understanding that include, we highlight 4 features in our epilogue. One is precisely this idea that both my co-editors have iterated that, in 2000, China was barely a player in Latin America. And by the time we were getting ready to publish this book, China had become the biggest export market of South America and among the top 2 trading department or top 3 trading partners overall. So there had been a huge change in the economic landscape and therefore the political landscape in the region that just had to be noted. Second, we noted, and this Sergio had already said, that there was just a broader set of actors that were making in and engaging in international law. It was no longer being forged by the cancillerías, by the foreign ministries, but also by NGOs, by domestic judges using international law, and in regional and international organizations. So there really is a sense of that we now have a broader set of actors that are participating in and shaping international law in the region. And through that, another through line was the importance of the Latin American law of human rights, embodied especially in the inter-American system. But the book showed us sort of in a bottom-up way how this had spilled out well beyond the inter-American system, and it was affecting domestic criminal law, environmental law, and litigation for constitutional rights at the domestic level. So it kept showing up as a factor in different chapters that were not supposed to be about the inter-American human rights system, but in which this human rights doctrines played an important role. So that sort of we point to as the area of greatest cohesion, development, and originality of Latin American international law. And then finally, and here Sergio has already spoken about the change in the scholarship, but I would just say we noted how through, as Alejandro said, a more formalized and institutionally supported practice of scholarship, we now have scholarship that is that has more funding and therefore can be empirical. So there's a greater interdisciplinary engagement in the study of international law in the region, a particular flourishing of the history of international law written by historians, and a move away from, not a move away from, but it's no longer just a formal debate, right? Formal doctrinal debate about international law. We now have scholars doing all kinds of different disciplinary takes on international law, and we have scholars from a broader, from different disciplines and from different walks of life. So we have women doing scholarship, indigenous peoples doing scholarship, and other individuals who were formerly excluded from the practice of academic study of international law. So all of this, of course, we do emphasize, we do make, I think there's a few unfortunate quotes that you could pick out from our epilogue, which say, you know, the Latin America is now turning away from the United States, or the United States is no longer the main interlocutor, etc. And of course, we close with this image, which happened, you know, basically a year after we turned in our book and made those statements. But there's, I would argue, and this will just be my closing, Wally, that despite the fact that the U.S. Latin America relationship is clearly back on the table and back in the news, that doesn't negate these features of international law that have changed since the Alvarez era and that we distinguish in the book. And I don't think that it changes the fact that China is now such an important player, and that the United States, even if it's back on the table, it's going to play necessarily a different role than it has in the past.
Thank you, Alexandra, and thank you, Alejandro and Sergio, for this first words for introducing to all the audience the book. So we now move to Cecilia for her reactions.
Okay. Thank you for the kind invitation to give commentary to this very important book that is so timely, given the challenge faced by the multilateral system and the fragility of the key principles of international law. The book successfully lifts Latin America out of the periphery, and it sits it squarely in the center of international law. I hope it will become a standard reference for all public international law scholars and practitioners. The book has a great description of Latin American internationalism that sought to eliminate foreign control of natural resources and economic dependency. It provides a thorough overview of the trends in international legal, normative, and political evolution throughout the region, dividing between those who supported the concept of a Latin American international law and those who did not believe that it was possible to distinguish it from universal international law. So I will first relate the book to the current context and then discuss some of the issues raised in the chapters and pose questions to the editors. So I apologize that I'm not able to address all of the chapters due to time constraints. So ironically, the book's last sentence reveals the importance of understanding history in order to tackle present challenges, as it points to the need to show how Latin American international law is moving beyond the US-led geopolitical era, as Alexandra pointed out. And at Davos, Prime Minister Carney of Canada declared that the neoliberal world order was ruptured. But President Alexandra Stubb of Finland argued that the global south, which includes Latin America, will determine whether the future world order will be based on multilateralism, promoting a values-based realism, defending principles, or instead multipolarity based on transactionalism. The chapters underscore non-intervention and sovereign equality as fundamental principles of Latin American international law, also recognized within the UN Charter. And I would add peaceful dispute resolution as well. The chapter by Scarfi sets forth that these principles place limits on powerful states to respect duties to small states. So I quote, By questioning the recourse to interventions, Latin American jurists consolidated not only the principles of non-intervention, inter-American multilateralism, and global modern multilateralism, but also the importance of recognition for the constitution of the personality of states under international law, since their contributions and the Montevideo Convention also shaped the formulation of UN Charter Articles 2.7 and 2.4. So the book's chapters have repeated references to the Calvo and Drago doctrines. These are arguably the most significant quintessential regional norms that are wonderfully described as having resulted in the legalization of diplomacy and the adoption of a legalist approach to international relations in favor of the principle of non-intervention. However, I must say there's a lack of analysis of the contextual examples in which these doctrines were contested or later supported, such as the wave of BITs in the 1990s and Brazil's reluctance to negotiate them. So I invite the editors to discuss their current relevance in relation to the Donroe Doctrine that seeks to counter investment from China and Russia, but supports U.S. investment in extraction of natural resources, including through the use of force. Isn't this a repeat of what Alberti qualified as intervention against intervention? Is diplomacy now delegalized, and can we reinsert it? So the unilateral actions taken by the United States in Venezuela violating the prohibition against the threat and the use of force, sovereignty, and territorial integrity were denounced in a joint statement by Brazil, Chile, Colombia, Mexico, Uruguay, and España, while Argentina supported President Trump's actions, arguing that it was an act in defense of freedom and actually joined his Board of Peace, thereby demonstrating fragmentation within our region. The joint statement underscored Latin America as a zone of peace and the primacy of peaceful dispute resolution. But many are concerned that the upcoming elections in the region will bring about right-wing governments that may further weaken the unity that Lula called for in an essay in the New York Times, where he noted the need for allegiance to the fundamental principles of international law. He characterized the region as one that strives for peace through the sovereign equality of nations, the rejection of the use of force, and the defense of self-determination of peoples, recognizing the pluralism of the region. And this indeed would align with Stubb's vision of values-based realism supporting multilateralism. But I'm afraid that after the elections, the region may not be as supportive of this vision. So my question to the editors would be, how can we support regional unity for these principles to support and protect multilateralism? And regarding the ICJ, the chapter by Valencia Espina and Vega Barbosa notes that since 1984, 26 new cases have been instituted by Latin American states, and only 6 cases have been discontinued. Hence, the region is identified as a strong supporter of the court. And the chapter further notes the referral of complex cases concerning maritime delimitation have enabled the court to maintain its traditionally paramount role in this area. So I wish to point out that the states that have withdrawn from the ICJ have involved offshore cases. So is it really true that the ICJ can maintain its paramountcy if the Latin American states are preferring to pursue political negotiation? And some may consider the U.S. action in Venezuela a measure to end the Essequibo dispute between Guyana and Venezuela. Hence, my question is whether our region is actually moving towards transactionalism and away from multilateralism in the area of offshore. And Sergio, your chapter on international economic law points out in a very well manner that in addition to highlighting imperialist relationships and unequal trading relations, the Latin American scholars emphasize the role of elites and corporate actors and asymmetrical relations between social classes as important elements of the dependency theory. So you discuss dependency theory as being a critique of internal class politics as it was of the international order. So this appears to remain a strong challenge today because of the polarization in our highly unequal societies. Are we now back to the future? Should we reapply dependency theory in the age of extraction? And you mentioned Hernandez Soto's approach to property formalization in relation to collective rights as a failure. So how does this play out in relation to the jurisprudence of the Inter-American Court of Human Rights that called for demarcation and titling of indigenous collective territory? States have not been implementing these decisions. What's the way forward for justice here? And you have positive notes where you're talking about the progressive CCT initiatives that seek to break cycles of poverty through conditions of cash based on school attendance. And I love this idea. There are countries in our region, are they moving towards creating solidarity economies? And one of the ironies raised by the book is that even though we may conceive of Latin America as one that rejects interstate violence, the chapter on IHL by Elizabeth Salmon notes that the growth of organized crime in the Latin American region has turned into a normalization of state of emergency declarations across the region and a militarization of security responses. So to fight against organized crime in this context, governments have adopted a narrative of war against crime. And we know that on February 11th, the US Joint Chiefs of Staff are gathering the military leadership from our hemisphere to discuss cooperation on drug trafficking and organized crime. So rather than being a zone of peace, should we be called a zone of undeclared transnationalized NIACs? So for Alejandro, then, my question is, when states are arguing that militarization and mass incarceration and application of state of emergency powers is the road to peace, how do we counter these policies within a region when we really have the fear of the example of Haiti at the opposite end? And the book highlights the contribution of Latin American women to human rights and women's sovereignty, as well as underscoring Latin America's humanization of international law, something that Judge Cansado Trindade deeply believed in, and through the contributions to the American Declaration of Human Rights and the Universal Declaration of Human Rights, and has a chapter by Alterio recognizing the court's protection of women's rights, and Huneeus' chapter on environmental rights. So I want to ask the editors whether would you like to highlight the contribution of any particular judges on the court as providing a counter voice to polarizing political narratives and providing leadership in international law through their decisions that promote perspectives of stewardship and care within international law. And Alexandra, you wrote your chapter before the Inter-American Court delivered the advisory opinion on climate change. So I'm wondering if you'd like to comment on the impact since it was delivered. Are you inspired the way it was written when it referred to principles such as solidarity that signal possible Latin American international law approaches? How did it measure according to your issues on climate justice that you raised in your beautiful chapter? And Jensen and Sicknick wrote this chapter on how Latin American states contributed to the right to access to justice based on the Amparo, but they also articulate duties in human rights. And I'm wondering whether we're at a time where we really do need to focus on the responsibilities of individuals and groups and business enterprises to implement human rights. And I ask this because many of our countries, the state is simply not present within the span of the territory. It's the non-state actors that determine the quality of life for many communities. And the militarization of the response to crime means that human rights may need to look beyond the state for champions of enforcement for human rights. And the book identifies one of the characteristics of the region is the pluralism of the people within, tracing the pragmatic choice of Argentina's constitutional drafters to, on the one hand, declare Catholicism the national religion, but also recognize freedom of religion given the presence of British merchants. And the compelling chapter by Barragán González on racism and exclusion is complemented by the chapter by Becker Lorca and Alves Marin, also recognizing that indigenous peoples' traditions were systematically repressed throughout the colonial period and denied minority treaty protection due to fear of weakening sovereignty and the implications of granting autonomy rights. And this issue is so prevalent today, given the impact of lithium mining, as well as other natural resource extraction that's dispossessing indigenous property. So given the weakness of our national institutions in providing access to justice to indigenous peoples, to what extent do we need to look for extra-regional innovations, such as the OECD national contact points, that are seeking to protect their territories due to the extraction from international companies that are headquartered outside of Latin America. And this then ties to the chapter by Gonzalez Ocantos and Sandholz on corruption. It's so compelling, showing the weaponization of anti-corruption, the danger to democracy, the due process violations. But another issue is how do we get accountability in the home states of these international companies that are engaged in corruption and return the funding to the victims in Latin America, because the West and the East are not interested. What strategies can we pursue to repatriate those funds to our victims? And then one area which Latin America has been really, really significantly impactful is refugee law. And this is not covered in the book because norms like placement of refugee camps far away from the border, the non-political characteristic of asylum, the need to broaden the definition of a refugee to generalize violence, this all comes from Latin American norms. And we have in practice the exemplary leadership of Colombia, giving citizenship to the babies born to the Venezuelans, really, really inspiring leadership in refugee areas. But we're watching that migration is completely securitized in our regions with mass deportations and detention, a state of unrule of law. How can we restore the rule of law in relation to migration within our region? I really want to extend my utmost congratulations to these three editors for this incredible volume. I know it's going to be useful to those working to define the contours of the new world order, because as Stu said, our region is expected to lead it. Thank you very much.
Thank you, Cecilia. So I bring back the floor to the co-editors of the book for comments on your inputs.
I think we can go in the reverse order. So maybe Alex starts, then Sergio, and then I just pick and choose whatever we want to answer. Is that all right, Alex? I'm not sure.
Unbelievable.
I can start as well. Don't worry. But, I thought it was
fair.
fair.
I was not thinking of starting. You start.
Okay.
I'm still digesting.
Sergio, are you okay with that? Yeah, no, that was a lot. So Cecilia, thank you so much. I think I can speak on behalf. That was fantastic. Those were many very good questions. The majority of them, I don't think we will have good plausible answers, or that anyone has very good answers to them. They're real difficult, sharp questions. So thank you so much, and thank you so much for the careful, detailed reading. That was impressive. Okay, so my proposal was not very successful. So I'll start. Let me pick and choose a couple of bigger questions. One has to do with, of course, the current moment and Venezuela at the center of that moment. And your question was, is our region moving away from multilateralism in favor of transactionalism, and what kind of responses can we expect from the region vis-a-vis the new context and the new policies of the US? So I will say three short things. The first one is that the intervention on Venezuela is perhaps the sharpest and clearest and more dramatic instance of a new dynamic of intervention of the US in the region and beyond the region as well. So Europe is now carefully discussing these types of interventions in ways that did not consider necessary before. Now, interestingly, Latin America is better equipped than other parts of the world to deal and administer and manage these kind of interventions to some extent, given its history and its experience during the Cold War. So as we've discussed with Sergio and Alex in many conversations, Latin America has developed a vocabulary. You very well referred to the Calvo and Drago doctrines and the language of non-intervention. So that vocabulary is a very important first starting point that helps us deal with those kind of interventions. But there are two other elements. One that I always quote Alex for this, which is the constitutional entrenchment of many international human rights law in many countries in Latin America by constitutional reforms, by Supreme Courts, and again that helps Latin American constituencies, including non-state actors, including NGOs, including politicians, but also including governments, to be able to resist some of these interventions by reference to its constitutional rules and its domestic entrenchment of international law. And the third, I think, dynamic that is also helpful to understand the ways in which Latin American states can deal with this type of interventions is precisely the lasting impact of transitional justice processes. And there's one story, I'll finish with this, that I think is very interesting, is that the government of Argentina, the Milei administration, was contacted by the US administration in order to send ships to the Caribbean before, so this was October last year. And the government asked the Navy, the Argentine Navy, and the Navy very politely and carefully declined and said, sorry, we are not in operational capacity to send the ship. But research has shown that this was partly true. Argentina was not in a technical position to send the ship, but also there was a serious concern by the military from the Navy that this would eventually create responsibility for them because of their story of being held accountable for unlawful acts under international law. So in a sense, again, world is difficult. Latin American states are again receiving the attention of the US in a way that they were not used to in the last couple of decades. But this history is helpful to administer and manage to some extent the new context. I'll leave it at that and leave Sergio and Alex to respond their questions.
Alex, you want to go first or should I go?
Sure, I can say a few quick things. I thank you, Alejandro, for jumping in. I needed time to digest. And much of what I was thinking is, as you spoke, Cecilia, is Alejandro has covered, which has to do with this entrenchment and domestication of international law and the institutionalization of it in such a way that it won't go away just through a change in the United States foreign relations, because it goes deeper than that. It's inside law schools. It's inside domestic litigation. In our book, we found it had influenced health law, corruption, in the Wayne Sandholtz and Oquendo chapter, as well as in the criminal legal systems. Like, there's a way in which this is no longer just something that happens, as I said earlier, in the Cancillerías, and therefore there is some stickiness to what we have pointed out in the epilogue as characterizing Latin American international law in the first quarter of this century. And then just two quick things, because I know we wanted, I think, to end at 12:30 to open for Q&A. So one thing is, I think it's really interesting in you said that in Davos, the idea was put forward, I think you said by, I can't remember, the Finnish Prime Minister, that the Global South it should determine this. But I think it's really interesting, and maybe Sergio can comment on the EU-Mercosur trade deal that has just been announced. So maybe this is not just the Global South, it's something that Europe and certainly Europe and Latin America have so much in common in terms of their commitments to multilateralism and international law and human rights, that we might see different alignments emerge that are committed. So we might get pockets of legalized juridical foreign relations alongside other types of more political raw power political relations. And then in answer to your question directly to me about my chapter and the advisory opinion issued by the Inter-American Court last summer, my chapter took it advocated for a more conservative line than the court actually took. I thought the Inter-American Court can't be issuing statements about mitigation goals and setting standards for the whole world when it's just a regional human rights court. And then the Inter-American Court comes out with statements about jus cogens obligations around greenhouse gas emissions. This is the Inter-American Court. It always goes further than I, as a risk-averse sort of legally trained person, would think it would or should do. And there's a way in which it's because of its constant conversations with activists, I think, with the strong role that NGOs end up playing before the court, it ends up shaping the court's understanding of climate change was basically constructed through the hearings and all the briefs filed that were mostly, the NGOs of the world, not just Latin America. So it'll be really interesting. I'm not saying it did the wrong thing. Probably I was wrong, but it was a really proactive activist judgment, and because of that very kind of forward-looking proactive stance ends up being used by NGOs and activists very actively on the ground, and in that sense gives it greater prominence than it might otherwise have had. So it's always interesting that with the Inter-American Court. And I think, and I've said this before, but it's the role of civil society in the construction of that has been greatly under-theorized. So I will now, given the short time that we have, cede the remaining 2 minutes to Sergio, but I'm sure that Joaquin will let us go a little bit over.
Well, thank you so much. And yeah, Cecilia, thank you. Those were amazing comments and very thorough. I perhaps start a little bit with a provocation by Alexandra about the EU-Mercosur agreement, and I think it's in fact relevant and to think about how cooperation will happen, what transatlantic cooperation we see and envision beyond the U.S. Right. So I have kind of like this belief that the European Union and Europe in general needs to see beyond that transatlantic view that was very North Atlantic centric, right? Like, it was always the US, and Europe, and that's the transatlantic relationship, right? So dismissing completely, other relationships and other histories, and I think this is the moment, and the EU-Mercosur kind of like signal that re-engagement, and then there's history there, right, as well, right? I mean, there's networks of people from different places in Europe that remain integrated, or at least active in the business endeavor with Europe, and the other way around, right? In Spain and Venezuela, you can see, the diaspora has been massive. Obviously, Spain and Mexico, Argentina and Italy, and or Chile and Germany, and you can find multiple connections that can be reimagined and re-engaged for more productive and more, in some way, fair arrangements within international economic law, right? I think that the view of Europe of itself right now, I mean, it's a view that is rather of not a muscular Europe, right? It's not the same Europe, that perhaps we used to believe, and right, like this the source of fashion, but also of this display of power. And I think like that can lead to much more or more equal engagements. And I think that's interesting. And I think like I can link this a little bit with your also mentioning of the methods section, right? My and other articles, right? And the development theory. And I think like how that actually permeates through different areas of law and development specifically. but also how Latin America tried to construct different states based on solidarity as well, right? I think the cash transfers, it's direct cash transfer is an experiment that started in Mexico, actually, with the Progresa movement, and then like that then was implemented by Brazil quite successfully as well. And I think like there are technologies and there are experiments that basically rely on this cooperation or cooperation with international organizations and the World Bank to try to improve the dependency issues that you mentioned. But perhaps given the time, I leave it like that, and I think maybe we can continue the conversation based off different Q&As or the Q&A section. Thank you.
Well, thanks to the three of you for the follow-up on Cecilia's reactions. We have a question from participants. I will read it, and I will also add something I was thinking about while you were speaking in these last few minutes. So we might run maybe beyond the initial allocated time, maybe for 10 minutes. We have two questions indeed. The first one says, thank you for the very nice presentation. I'm wondering, Latin American countries often emphasize respect for international law in their rhetoric, but recent events, such as the invasion of the Mexican embassy in Ecuador, reveal inconsistencies between discourse and practice. Amid rising regional tensions, also mentioned in your presentation, what do the editors think about lax actual commitment to the core principles of international law, such as the Vienna Convention on the Law of Treaties and the Vienna Conventions on Diplomatic Relations? And the second one says, by Daniela Ospina, thank you for the webinar and the wonderful insights from your book. I'm a Colombia lawyer and a former EVA student of international security. In the past few weeks, the Trump and Petros administrations have come closer to a fluid relationship regarding the fight against drugs. We're waiting for their meeting in the upcoming weeks. How likely do you see a return of an alliance such as the Plan Colombia? And how would you envision the Trump's administration's justification to intervene in Colombia again in the framework of international or national security? And just to conclude, I would like also to add a very brief question. Throughout your interventions, the idea of a certain entrenchment, of potentially this new canon you refer at the end during the across the epilogue of the book came up a lot. And of course, the current scenario, it's kind of an invitation to think how we can make that canon survive in time. Where do you think there are specifically interesting spaces, actors, considering the diversity and multiplicity of voices that are part of this new canon compared to the initial one, that we should be looking for in terms of their dynamism to help us preserve for the future some of these interesting achievements that you highlight in the epilogue about human rights, integration, regarding this new canon for the 21st century. So I don't know who would like to start reacting to this set of questions.
I fear making any suggestion because it can turn very easily against me. So, Sergio, do you want to say something about the Mexico-Ecuador situation, or that might be?
Yes. Well, it's obviously a very complicated issue, and I think it highlights a little bit of a topic that Cecilia was raising before, right? How there's a fragmented Latin America, right? In a way, I think our exposition and at least the idealization of Latin America tends to be this continent that has uniformity, but in fact, there were very clear tensions, at least for some time, right? And that they are being withdrawn as well, right? There was the famous ALBA, right? Countries, right? Like, so we have when Venezuela and Argentina and Nicaragua, they were more left leaning, and then like that changed, right? So for some time, Mexico was much more Colombia, Mexico, and Chile, and it's true that that tension really has changed. But I think what's interesting is, despite those fragmentations, I mean, we don't see the level of conflicts that you would expect, right? I think like the level of even the conflict between Mexico and Ecuador, and the invasion of the embassy, that is a response, according to Ecuador, to also the violation of the airspace and other questionable acts of the Mexican governments. Well, at the end was treated by, or is being addressed by the ICJ, right? I think that's all what I would say, right? I think there are divisions, and those divisions have been reshaped. And I think Argentina is a big example, with joining the Board of Peace, and where probably 5 years or 10 years will be also being very upset about what happened to Maduro. But maybe Alex or Alejandro, if you want to join me on something. Or disagree.
I can go.
Oh, okay, thank you.
But I don't know. I mean, I'd rather.
You'd rather I go. I'm not sure. When I think about the question, about how committed is the actual commitment to core principles of international law is the question. And of course, I think throughout the history of Latin America, you can point to moments in which Latin American particular governments have not respected core principles of international law. But that ultimately, I think there's a sense in the region, which is probably right, that for the smaller countries of the world, the rule of law is a way to curb power, and therefore ends up being something that ultimately Latin American countries support, despite these moments of for politicization that lead to non-respect for particular principles. So my prediction, because this is really about sort of what's a lot of this conversation is about predictions, which is what's making me a little bit uncomfortable. But my prediction would be that ultimately Latin Americans, they understand, right? Many governments, NOAA, understand that they can get a lot by kowtowing to the Trump administration. But I think states also understand that ultimately the rule of law, international rule of law, is something that will help them tame the power of the United States, and therefore ultimately they adhere to it and support it. I think it's interesting because Sergio mentioned ALBA. I always thought it was interesting that Chavez, who was so, anti-OAS and UN, was so interested in creating alternative venues using international law, right? So creating ALBA and other organizations. And it's therefore interesting for me to see Trump now trying to create the Board of Peace and using international law to do so, right? So using the norms and principles and laws and that are pre-existing in order to create a new institution, maybe bypass the UN Security Council, but nonetheless relying on law. So I see a similar dynamic to Chavez in that respect. And now I cede to you, Alejandro.
So very briefly, let me address Daniela's question and connect it to something Cecilia also mentioned. Daniela, you're talking about the use of force against drug trafficking and how that is regulated, and the possible connections between Trump and Petro and possible agreements. I don't know. They're such personalized governments that it will depend on the chemistry, I guess, to some extent that they have in that meeting. So I have no idea what there's gonna but there's a deeper sense in which I think international law is present, and this follows neatly from what Sergio and Alex was saying. Cecilia, you were mentioning about the growth of organized crime and the use of IHL to address organized crimes, and you mentioned this zone of undeclared transnational, non-international armed conflicts. And what I think is interesting, so I've been, and many other colleagues have been very critical of the use of IHL to address this type of actor or this type of threat. But what is interesting, and this follows neatly from what Sergio and Alex were saying, is that the justification is still a justification of international law. So the governments from the region, even when they pursue policies of which many of us are highly critical and challenge them on legal, international legal and constitutional grounds, they still argue on the basis of international law. And that, I think, is quite unique and quite important, and something that is as Ali was saying, sticky and entrenched, and it will be, because of our history, because of our position, our geopolitical position, that's going to be very difficult to get rid of, I think, or quite difficult. And let me finish with a point that Joaquin was mentioning. Where is this conversation? How can we continue this conversation? Where can we find more international law? So I think this type of event is precisely the type of fora that push the conversation forward and create synergies and create and develop ideas and intuitions. But I also take the opportunity to highlight or to mention a few other developments which I think are important. With Alex and Sergio, we have we have proposed Oxford University Press to launch a new collection of a new series of books on Latin American international law. So, and part of that idea is precisely to look for voices and ideas from the region, about the region, on the region, by people on the region working in other places, but essentially or mostly also people working in the region, proposing new interventions, contributions to international law. And that's a space that we want to foster in order to have a broader conversation, again, like this, in a very with a very global audience, or with global reach at least. There is the Society for the Latin American Society of International Law, the SLADI-LASIL, which is doing its biennial conference in different parts of the region, which have been very well attended. The discussions have been great. And that's another forum that I think is relevant. And there's a new journal on Latin American and Caribbean international law that is about to be launched, or is being launched as we speak, which again provides another space for continuing the conversation. I think it is important to acknowledge the work of each other, to talk about the work of each other, to discuss the work of each other. I think that's a central aspect of what we're trying to achieve, and a central aspect of what the book was trying to achieve. So we, again, thank you very much for the space and the opportunity to discuss it with you and the audience.
And I just want to jump in and also thank Cecilia for a really, thoughtful and erudite set of comments. It was very enriching to hear the book from your view. I forgot to say that earlier, but it was very impressive. Thank you.
I will also want to join Alexandra and Alex and Alejandro in this, in thanking you, and Cecilia, thank you for the amazing work, and thanks for the invitation, and hopefully we can continue the conversation in another place. Thank
you. For sure. Thank you, Sergio, and Alejandro and Alexandra for those last few words. We had a third question, but we don't have more time. But as Sergio said, and also Alejandro provided a very interesting account of the multiple spaces we have to continue with these conversations, because Latin American international law is very much alive, and there is a lot still to be discussed and argued and protected in many ways. So I would like to thank, first of all, to the panelists for presenting the book, and to Cecilia for his very detailed and precise comments on such an important piece for the scholarship in Latin America, the Caribbean, and international law. And of course, a big thank to everyone who has joined us at these very late hours, at least from the European side of the world. And I hope we can continue this, as I said initially, this conversation in many other places, in person, remotely, in the near future. Finally, this conversation will be uploaded very in short to the YouTube channel of the project. So if anyone wants to go back to any of your interventions, you can do so through those via YouTube. So again, thanks, and hope to see you soon in future conversations.